Hi, today on Criminal Law TV, we're going to go over the changes in Virginia's laws having to do with violence, sex, and theft. So, without any further ado, let's get going.
The number you have reached, 911, has been changed to a non-published number.
Okay, so, hi, I'm Ken Lammers. This is Criminal Law TV, and what we're going to cover today are what the General Assembly's changes in the laws having to do with violence, sex, and theft have been. All these changes went into place at the 1st of July 2013 and should apply going forward. So let's start with the violent crimes. The first one, under 18.2-57C, which is the felony assault and battery without injury or wounding, just plain old felony assault and battery, usually having to do with the status of the person being attacked. 18.2-57C, they've added magistrates to the people who, if they're attacked, it's a Class 6 felony with a mandatory 6 months in prison. They've also made it a Class 6 felony to assault and batter a person, basically a doctor or nurse, at a healthcare treatment person at a correctional facility. So those have both been added to the mandatory felony assault and batteries. Abduction, 15.2-1724 is a statute which allows police officers to leave their jurisdiction. I would say it's either a pursuit statute or a statute where there's a serious problem in another county which has asked for aid. There's a list of things under the statute, but this year they added abduction. And if an officer is sent, he may go lawfully beyond his jurisdiction, even beyond his state, to assist in an emergency. So, they can lawfully go to, like we border Kentucky, could lawfully go to Kentucky to assist in an emergency. Obviously, anything done in that state would have to be pursued in that state, but the police officers and deputies from Virginia could go there to help. Stalking, 18.2-60.3B has changed so that any person convicted of a second offense of stalking occurring within 5 years of a prior offense of stalking, when the person is also convicted within that 5-year period of various felony assault and batteries, or just regular assault and battery, with the victim being the same as the victim in the stalking activity, or domestic assault and battery, or violating a protective order, is guilty of a Class 6 felony, up to 5 years in prison, if somebody jumps through all those hoops. So that's got to be at least 2 prior convictions within the last 5 years. That's just maybe just too complicated really for it to be prosecuted unless the person is seriously peeved off the prosecuting attorney. 16.1-106, a protective order remains in place during an appeal unless the court above overrides it. So this is, that's the way it's always been for JDR protective orders. This is putting it in place for non-juvenile and domestic relations protective orders. So a couple of years ago, they went in and they put in a whole bunch of new protective orders that can be sworn out and put in place that don't have to have anything to do with juvenile or domestic relations court. And this is just filling in some of the loopholes they left behind. Sex crimes. Cohabitation. Those of you who may have partaken in cohabiting with somebody of the opposite sex will, I guess, be relieved to know that 18.2-345, which made it a crime to cohabitate with somebody of the opposite sex, has been taken out of this code by the General Assembly. So it is now legal to cohabitate with somebody of the opposite sex. Thank goodness. Underage. Anybody who solicits prostitution from a minor 16 years of age or older is guilty of a Class 6 felony, up to 5 years in prison. Younger than 16 years of age is guilty of a Class 5 felony, up to 10 years in prison. This is opposed to normal solicitation for prostitution, which would be a Class 1 misdemeanor, up to 12 months in jail. And that statute is 18.2-346. 18.2-370A3 says it's illegal to propose to a minor under 15 that minor fondle his or her own genital or sexual parts. That's a Class 5 felony, up to 10 years in prison. 18.2-374.3C2 says it's illegal to use a communication system to propose that a minor under 15 fondle his or her own sexual or genital parts, and that is a Class 5 felony as well, up to 10 years in prison. 18.2-64.2 says it is now no longer legal for a bail bondsman to have sex with someone he's bailed out of jail. I'm sure there's some people crying about that out there. House Bill 1862, which adds on to 9.1-902, added a whole bunch of a whole bunch of crimes that would require someone to register under the Sexual and Violent Crimes database. However, there are just basically the same crimes that are there now. It just went back to old numbers, which they used to be covered under, which older statutes, which used to cover the same things the newer statutes do. Theft, rental theft. Okay, 18.2-118. This is the statute that allows these rental companies, after someone has broken the lease and not returned that $3,000 TV or some such thing. It previously allowed them to go get a larceny warrant after 10 days. It now allows them to go get a larceny warrant after 30 days. It changed the amount of time that they have to wait from 10 to 30 days. ID theft, 18.2-186.3D. Stealing the ID of 5 people is now a Class 5 felony, up to 10 years in prison. It used to carry up to 5 before. Stealing 50 people's ID is a Class 4 felony, which is 2 to 10 years in prison, and it used to just be up to 10 years in prison before. And if using a false ID results in arrest of a person who should not have been arrested, that's a Class 5 felony, up to 10 years in prison. That used to be up to 5 years. So they bumped all those up. Scrap metal. Metal theft seems to have died down lately. I'm told that has something to do with the price of metal going down. I don't know. I don't turn in a whole lot of scrap metal. But the General Assembly is still tweaking those laws, trying to make them work better. They did change all these laws. All these laws used to apply to scrap metal processors, people who actually processed the metal and broke it down for sale and stuff like that. Now they've changed it to scrap metal purchasers. Probably a better term to use because there were a lot of people that would just buy the stuff and then sell it to a processor and would try to claim that the law didn't apply to them because of that. However, let's go on. 59.1-136.3C is changed to say that a scrap metal purchaser shall take a video or picture of a proprietary item. Proprietary items are items which can't be identified, which probably came from a specific location. And 59.1-136.1 has been changed. Now, in there's a huge list of proprietary items, and this year they added new proprietary items, which included manhole covers, bronze or copper cemetery plaques, aluminum bleacher seats or guardrails, or mining cable that is 1/2 inch or greater in diameter, is composed of one or more stranded copper conductors and stamped, engraved, stenciled, or otherwise marked with Mine Safety and Health Administration, or MSHA. Every year they seem to add some sort of new mining cord or something in there. I guess that's hitting some sort of moving target. And those people who are own pawn shops or places that take in precious metals and gems, there were some specific changes to their laws too. 54.1-4009 A, 7, and 8 were changed, and a pawnbroker now has to keep a digital image of a government issue ID of a person who sells them something or who pawns something with them. And 54.1-4010A says that when they turn in their daily report to law enforcement of those things that have been pawned with them, they must include the picture or digital image of the person who pawned it or sold it. 54.1-4009D says a pawned or sold item cannot be resold if the serial number has been messed with, damaged, eradicated, anything, can't resell it. And 54.1-4101A4 now says that a buyer of precious metals or gems must take a digital image of a government-issued ID of the picture of the seller or the pawner, I guess, if they're actually taking it as a pawn. By the way, these government IDs in both cases have to be picture IDs. So basically, in Virginia, that means they'd have to get them from DMV, even though they're not license plate or driver's licenses. DMV issues other government issue IDs. So that's it for today, folks. Tomorrow we should hit, at the very least, weapons and driving offenses, and probably the others, whatever's left over, and that should complete it for us. I'll see you then.